Liar. Everywhere. On netrootsradio.com. David Waldman. Kagro. In the morning. Now, here's David Waldman.
Hey, good morning, everybody. How you doing? You should answer me now. All right. Hey, great. Good to hear. It's Friday, August 18th. What a fantastic time for you to be feeling so, as you said to me. And Friday, August 18th, 2023. In case you didn't know what year it was, instead of doing the traffic and weather here on the show, we remind you what year it is. We're very useful. Okay. Well, it's Friday, and you know what that means. And that's why I don't explain it to you. I just tell you it's Friday and that's it. As for the show, it usually means batting a little cleanup here and trying to take care of some loose odds and ends that are in pocket, and there are plenty, but there are a lot of long reads to get through too. So I don't know exactly how things are going to go. But what can I tell you? We'll get to a bunch of these things. There's definitely a few things that I think we've neglected that we ought to try and sneak in. But yesterday, when we left off, I had probably unwisely begun a long read over at Lawfare about what, as they titled it in their piece, what the heck happened in Coffee County, Georgia. And they know, and it's important for us to know. I think it will probably have to substitute for reading the entirety of the indictment, as much as I enjoyed doing that with the federal indictment, and as much as I think that the Georgia indictment might even be the more important one, I think we all kind of know the story by now. So it might behoove us, it might better benefit us, let's say, to read in-depth explanations of some of the foggier notions from the Georgia case, and in this case, the Coffee County voting machine break-ins, essentially, are the most mysterious part. I mean, I think we all understand. It does pay, I think, sometimes to read through the indictment and read the narrative of what is conspiracy, why does it work the way it works, how come people can, for instance, be held liable in a conspiracy even if they didn't necessarily know what all the rest of the people in the conspiracy were doing. The answer came yesterday as I pulled a fact out of like law school training, the hub and spoke theory of conspiracies. So long as there's one hub at the center who knows more or less what the entirety of the plan is, it's not actually necessary, in order to rope people in with criminal liability, for them to know what the other people on the other spokes are doing. And you understand the analogy there, or the metaphor to the hub and spoke, like on a wheel, a hub at the center of the conspiracy that is in touch with all of the various actors one way or another. Sometimes directly, sometimes indirectly, but like a wheel, a hub from which the spokes radiate towards the actual rim of the wheel. But in other words, there can be actors out at the other end of each spoke, and they don't know anything about what those on the ends of the other spokes are doing. They only know about their relationship with the person at the center, at the hub, but it is through that hub that they connect and move together. So I wondered whether I had to explain that metaphor or not. All right, well, let's see. Things for us to get to today. Let's jump back to Lawfare, just by way of reminding you. I think we left off in section, or after section 3 here. What they were explaining through the first couple sections was, one, the basics of what was going on in Coffee County. Why was Coffee County of interest to the Trump campaign, given that it was a Republican stronghold? It's a small county, it's rural, there aren't that many voters there. There weren't even any, at that point, serious allegations necessarily of massive fraud going on in Coffee County. And you might have wondered the same thing about Antrim County, Michigan. Again, a place where Trump was expected to win overwhelmingly and did. Now, Antrim County had the additional intrigue of having the early mistake made in the programming of the machines. Well, I guess so. In the programming of the vote counting, the tabulation function of the machines. I don't know exactly. They don't ever really explain what it is, and maybe it's just so highly technical, but it was human error that caused the votes to be tabulated incorrectly. And it may just be like, column 1 says name of candidate, and column 2, and then row 2, 1 or row whatever saying Biden and or Trump, and they forgot about the empty row that they needed in order to, build the matrix, etc. You understand what I mean? I don't know if I'm explaining it correctly, but anyway, if you had said like with an Excel spreadsheet, well, okay, take everything in column 1 and add it up, and that will be what Biden's vote is, and take everything in column 2 and add that up, and that will be Trump's total. And then you realize, oh, actually, I used column 1 for the labels of the names of each of the candidates, not the numbers. And so what ends up happening is it totals the vote for, it totals it backwards. And said, or, it could be something as simple as they didn't do anything like that, or they didn't, it's not that they didn't shift over one, but they may have totaled them backwards. I listed the candidates in alphabetical order and I forgot that. And I said column 1 would be Trump and column 2 would be Biden in the please output the numbers here. And I realized I reversed them, something like that. That's the sort of error that they're talking about. And they very quickly detected that because, as I said, the election officials there knew that Trump should be winning that county overwhelmingly. And as soon as they saw, hey, it's going the other way, they went back and said, oh, I swapped these 2 columns or whatever it was and switched them and said, all right, this is the result that I thought we were going to get. The numbers are the same, but they're just switched for which candidate it is. And of course, the conspiracy-minded Trump troops looking for something like this and hoping to be able to pin some sort of claim of fraud to it said, this is a voting machine. It's flipping votes. People are coming in and pressing the button for Trump, and it's tabulating them. It's counting them as if they were votes for Biden. That's what's happening here. And no, the machines were counting the votes right. The operator simply asked for the output to be expressed in a table that they had accidentally flipped due to their own human error. So anyway, but that became, of course, we found, fraud going on, and let's investigate this. And how many more places in the country could this be going on? And the answer was 0, because only one place actually made that mistake, at least for long enough for the results preliminarily to have been reported incorrectly. Coffee County they were mostly interested in because they wanted to be able to get access to voting machines to prove their strange theory that something somewhere inside these machines, and I understand the inclination to think of these machines as black boxes and therefore unaccountable, and that, you need some sort of verification of everything, and you do. I understand that, but they're just sort of exploiting that by saying, all right, well, everybody knows that software, there's no physical representation of the votes. There needs to be a paper trail, or we need to be able to audit the machine and see what is the coding? How does it add these things up? And, you're typically not allowed to just go grab that and take a look at it. One, the coding is considered to be proprietary because private companies make these machines. Maybe that's a terrible idea, but that's where we stand with it, having litigated this 100 times in the early 2000s. And secondly, of course, these machines have to be held in government custody and kept from the hands of those who might otherwise seek to manipulate them. We don't know anything. People say, I just want to do the right thing and audit how they work. I have no designs on changing the vote now or in the future. Wink, wink. But do they? Is that really true? Or are they saying, well, let me examine the code, i.e. also slip some malicious code in there that will rig the next election, or plant what looks like evidence of rigging this election. We don't know what they're up to, and that's why you can't just lend the machines out to anybody who wants to look at them and use them. But so most jurisdictions were very reluctant to allow anybody outside of the officials who usually handle and care for the custody of these machines to touch them, look at them, use them, open them, anything. But in Coffee County, they found enough sympathy among the Republican elected elections officials, yes, the elected elections officials, who are entrusted by virtue of having been elected to this office. In some cases, in some states, they're appointed to the office, but I guess there they were partisan Republicans who had been placed in this office through whatever mechanism, and they found people willing to say, to hell with it, we'll let you in, we'll let you open the machines, we'll let you copy the software and examine anything you want, because we think it will result in the sort of discovery that you'll be able to build a case on and claim nationally that the vote was manipulated and therefore Joe Biden really isn't the president. Please use our machines. We'd be honored to have you use our machines to prove that Donald Trump really, really, really won the election. And they just opened their doors. And it happened to be in Georgia, and they happened to have a prosecutor who was interested in taking a look at this. It didn't happen in a whole lot of other places, but it did happen in a few others. We've read the saga of what happened in Colorado, whether or not it was in coordination with people connected to the White House and their conspiracy or not. That's not yet been proven, but it's entirely likely because apparently, just like in Coffee County, I think the data from the Colorado machines was likewise shared online and by some of the same actors accused of sharing this data and these forensic images in Coffee County. So I think, anyway, we'll pick up with, I think it's Section 3, or, well, maybe we did do Section 3. Did we make it all the way through Section 3? Yes, I think we may be... No, perhaps not. I think I saw the beginning of it, but we didn't jump in all the way to Section 3. So Section... maybe I guess should scroll back through these actual section narratives of the sections and give you the top lines on each of these parts. So I guess Section 1 isn't actually labeled here, but this is the one where we just discussed everything, and we remind you that crazy Sidney Powell had engaged the Atlanta-based firm Sullivan Strickler to do the forensic imaging, so quote unquote, both in Antrim County, where they actually, one, there was that mistake that prompted all of the suspicion. Then two, they actually went to court and got some authorization from a local court of, more or less competent jurisdiction, and got the order to go ahead and do this forensic imaging, and they hired this Sullivan Strickler firm. Why they hired an Atlanta firm to do the work in Antrim County, Michigan is unclear, but, we work in a national economy these days. It's not that suspicious. But then, as it turns out, it was handy to have them based in Georgia because then when they later got access without any proper authorization to Coffee County's machines, they were able to use them to do the same work down there. So we learned the names of some of the actors there, and that was the basic introduction here. Here's Section 1. It was Section 1 when begins with essentially Giuliani, described here by Jason Miller as being definitely intoxicated on election night, begins hatching inside the White House anyway, I guess for the first time, expressing these strange ideas about what they ought to be doing with the voting machines around the country. So let's see. Bill Stepien is in there, Trump's campaign manager, telling him, no, it's too early to do this. It's too early to call the race. It's too early for you to go out there and say you won. Jason Miller had advised him to put off declaring victory until there was a better sense of the numbers. Ivanka says, just tell your people that the votes are still being counted. But he sides with Giuliani. 2:30 a.m., he goes out and delivering remarks from the East Room of the White House, declaring not only that he had won, but this was a huge fraud He said, a fraud on the American public, an embarrassment to our country. And then that weird line about we were getting ready to win this election. Frankly, we did win this election. Okay. Then a recitation of all the weird theories people had about dead people voting, suitcases full of ballots, Hugo Chavez, Chinese thermostats, etc. It starts to get weird. Section 2, approximately 1 week after Biden won the presidency, the Coffee County Elections Board gathers to discuss the outcome of the elections. And all of these weirdos, including Misty Hampton, also known for some reason as Ms. Martin for some reason. Also Emily Misty Hayes, apparently known by all these names, and all of them are named in the Fulton County indictment, all getting together and pressing this case and deciding that they definitely, totally, absolutely were sure that there was lots and lots of fraud. And remember Eric Cheney saying, it sickens me, it sickens him to know that the machines could be used for fraud. So they begin to look into them. All right. So what's going on here? In reality, Georgia's state elections apparatus has audited the vote, counted, recounted, and counted again. And finally, a third machine count produces the same answer. Georgia's Secretary of State certifies Biden as the winner of the presidential election, in Georgia anyway, but the Coffee County Board of Elections at this point refuses to certify its machine count numbers, citing an inability to repeatedly duplicate creditable election results, which is, I guess, the fanciest way they could find, the most legalistic looking way of saying, well, we're not going to certify because we can't get the same number twice. So therefore, we can't verify our results. What's going on? Well, as it turns out, the county's recount amounted to a 51-vote discrepancy with its election night tally. As they say here, a sum that would have been far from sufficient to alter the outcome of the election in Georgia. And the board also neglects to specify how problems with the machines could have caused differences between the counts. We think there's fraud being perpetrated by these machines. We want forensic imaging and we want investigators in here to look at the code. Yeah, well, but why? Well, because look, we have this 51 vote discrepancy. Yeah, well, are the machines responsible for the 51 vote discrepancy, or was there some other error going on here? Look over there. That's their actual answer. So, okay. That's what's going on down in Coffee County. And now I think things begin to get really weird. On December 18th, 3 weeks before the breach in Coffee County, a screaming match broke out inside the White House. This is the so-called unhinged meeting that, what's her name? I forget the name of the witness that was briefly famous for testifying to the January 6th committee about it and calling it an unhinged meeting. But the name probably comes up here somewhere in the report. And if not, you know who I'm talking about. And if not, look it up. It doesn't matter. Really. But anyway, 4 days earlier, this is the screaming match is on December 18th, but just 4 days earlier, members of the Electoral College had convened in state capitals, that would be December 14th, across the country to enter their electoral votes for president. A joint session of Congress was set to be held on January 6th, to count the electoral votes, you know all about that, and declare Joe Biden the winner of the election. In 7 battleground states, including Georgia, purported Republican electors had assembled to submit an alternate, quote-unquote, alternate slate of electoral votes for Trump. These contingent slates, again, closed in scare quotes, according to the plan constructed by Trump's legal advisors, could be used to block or delay certification of the election if Trump won any of his pending legal challenges contesting the election. You know about that, and you know about how the goalposts moved. Alternatively, the false slates could come into play if state legislatures convened a special session to appoint electors who would override the popular vote in the state. If all else failed, Vice President Mike Pence might have been convinced, he wasn't, to unilaterally decide to count the Trump slate instead of the Biden slate, or at least use the conflicting slates as a reason to count neither, or otherwise kick the issue back to the state legislatures. Prior efforts to get access to voting machines had largely failed. Powell said the judges who had ruled on Trump's legal challenges were corrupt. That was the excuse in this unhinged meeting. They kept saying, we got to seize the voting machines. Well, every time we've gone to court asking for access to the voting machines, they've said, no, there's no basis for it. Yeah, well, they're all corrupt. Every single one of them, 60 times over. They're all corrupt. We have to go around the corrupt judges, says Sidney Powell. This all according to the recollection of former White House counsel Eric Hirschman, not the witness I was thinking of, but he too would doubtless have said things were a little out of control there. Now, Powell felt that time was running out to preserve evidence from the machines. She later told the January 6th committee it was time for Trump to act. And maybe we even add some dramatic music to that. Powell's team, to the extent it was one, had a plan. The federal government could seize voting machines in the states under a 2018 executive order. It's linked herein if you want to take a look at it. It's Executive Order 13848. Okay, imposing certain sanctions in the event of foreign interference, I guess, in an election. Probably came after 2016. But anyway, it was an idea that Powell had been mulling before she arrived at Tomotley. Remember, that's the South Carolina estate of Lynn Wood, in late November. Ever since she'd heard the quote-unquote cyber guys talk about the prospect of obtaining hunting licenses. That in scare quotes too. What's a hunting license? That is a search warrant. That's how they referred to search warrants, to seize and inspect voting machines, according to her testimony before the January 6th committee. Probably should have been described as fishing licenses, since it was a fishing expedition more than a hunting trip. But anyway, they wanted to bring guns into it. Days before the December 18th meeting, Powell and others holed up in a hotel in Washington, where they drafted two versions of an executive order that they wanted President Trump to issue that would have authorized the federal government to seize voting machines from the states. One, dated December 16th, would have directed the Defense Department to seize voting equipment. The other, dated December 17th, would have directed the Department of Homeland Security to do the same. Both referenced alleged voting irregularities in Coffee County as partial justification for the order. So again, just wanted to let you know, or emphasize for you, crazy Sidney Powell is having fantasies about using idiot Trump's brain to give form and substance to her wacky theories by having him issue an executive order seizing voting machines nationally based on a 51-vote counting discrepancy that they were conveniently handed by Coffee County friendlies. And that's the whole thing. 51 votes, and all explainable by anything other than the machines, and not outcome determinative, but she was going to have the military, the Department of Defense, seize all voting machines in the country because Coffee County couldn't add. That's basically what it comes down to. Last year, emails obtained by Politico revealed that the draft orders were workshopped by multiple people, including Waldron and Flynn, previously introduced. Mike Flynn, of course, is Flynn here. Catherine Freis. I don't know who this is. Wasn't this... that's a familiar last name. Is that, wasn't there a billionaire financier backer of the Republicans by that last name? I forget what his first name was, but it was an FF, wasn't he? Anyway, I don't know if they're related. Catherine Freis, Freiss, an attorney working with the Giuliani faction of the Trump campaign team. I love that they have factions. Christina Bobb, One America News anchor, and the one who swore the affidavit out at Mar-a-Lago over the documents. Remember her? Lunatic. Also, Bernie Kerik, also frequently referred to as a lunatic, an investigator working with the Giuliani legal team and an ex-con at that from 9/11 days, also received emails discussing the draft orders. On December 18th, Powell, joined by Flynn and Byrne, that's Patrick Byrne, the Overstock.com guy, set out the executive order proposal for Trump during an impromptu meeting at the White House. According to the testimony of multiple witnesses before the January 6th committee, in that meeting, she also urged Trump to appoint her as special counsel to investigate voter fraud, according to deposition testimony and the January 6th committee report. Here, again, extremely dangerous period of time. And getting into Trump's infected brain and controlling him like a fungus. I've been watching The Last of Us. She comes this close to being able to dictate the content of executive orders and having him spit them out verbatim, and appointing her special counsel, giving her all sorts of powers and resources to do her quote-unquote investigation, and then not be dislodged by the incoming administration. She could just have been there embedded in the government during the Biden administration, causing havoc by saying any kooky idea she came up with had to be investigated at the cost of untold millions of dollars for nothing, for no good reason, because her infected brain said so. That's it. And thankfully that didn't happen, but that's a major breaking point in this conspiracy. Now, this incident shows up as Act 90 in the Fulton County indictment, which alleges that the individuals present at the meeting discussed certain strategies and theories intended to influence the outcome of the November 3rd, 2020 presidential election, including seizing voting equipment and appointing Sidney Catherine Powell, in all caps, the way they do with suspects and indicted people, as special counsel with broad authority to investigate allegations of voter fraud in Georgia and elsewhere, just in case you thought it stopped at the Georgia line for some reason. Other factions of Trump's inner circle argued against Powell's plan because it's crazy and she was a lunatic, and they weren't, apparently, as jerky as they were agreeing to work for a Trump administration. They weren't this crazy. According to his testimony before the January 6th committee, Giuliani told Trump that signing the executive orders would be the only thing he ever did that, quote, could merit impeachment. So, in case you were wondering just how crazy it was, even Rudy Giuliani recognized at the time, right there in real time, that appointing Sidney Powell special counsel and seizing all the voting machines at the authority of the DOD, crazy.
Sup, fam? It's your boy Darwin, aka Darwin_Darko, aka the most reasonable man in America, aka KITM's senior black correspondent. You might remember me from such recordings as Spacemen vs. Space Cadets and We Need to Talk About Joe Biden. Today, I want to bring you good news about that thing you've been struggling with. Do you suffer from giving too much of a damn? Do you turn on the series of tubes and find yourself outraged at the particular way some news organization strung some sentences together only to realize, nope, this is not some fictional hellscape? Well, guess what? You no longer have to accept the life of giving too much of a damn. You can do something about it, because even you, yes you, can be a show contributor. Now I know what you're thinking. Hey, Mr. Most Reasonable Man in America, I'm not some professional podcast talking guy. Don't worry about it. Do you have a smartphone or some other electronic recording device? Well, that's all you need. You too can have a segment where you can read us an important article and give us your take. Read one of your own original essays, or even just give us your commentary on something you'd like to share that's important to you. Fair warning though, side effects may include general punditry, having opinions and hot takes, getting stuff off your chest, and hearing your own voice. If your recording lasts longer than 5 to 7 minutes, please consult kagrox@gmail.com. That's KAGROX@gmail.com.
All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. We continue. It's a long read. We'll go. We're getting towards the bottom half of it here, so not too bad. Hopefully we can race through. Again, I'll renew my focus here. But I am astonished to announce to you that it is so obviously crazy is Sidney Powell's plan on December 18th during this unhinged meeting that even the unhinged Rudy Giuliani says, no, this is crazy. We can't do this. And if you do, that alone could merit impeachment, let alone what ends up happening on January 6th. But, okay, interesting. Derek Lyons, a former deputy White House counsel who attended the meeting, told the January 6th committee that Giuliani proposed an alternative. What is his brilliant alternative? Voluntary access to voting machines. Oh, as opposed to seizing them. And I guess this is how the plan evolves at this point, right? Well, we can't. It's too crazy for us to use the military to seize the machines. But what if we got voluntary access granted to us? Where would we get something like that? A place like Coffee County, where Republicans control, well, specific kinds of Republicans control the election apparatus and have the keys to the rooms where the machines are and whatever else goes into turning those machines back on so that they can recount. Get back in there, sell. The machines will take care of it. So, voluntary access to the machines becomes the plan. Georgia was a topic of discussion at the time, he said. That is to say, Derek Lyons, the former deputy White House counsel. According to Lyons, Giuliani's point of view, quote, was that in some way the campaign, I believe, was going to be able to secure access to voting machines in Georgia through means other than seizure. Although, if you are not authorized to go into those machines and do whatever the hell it was that they did, if custody should not be turned over to you, it's essentially a seizure, isn't it? It's just not a state seizure by force. It's a bunch of lunatics seizing it by, by artifice. At any rate, similarly, Powell told the committee that Giuliani said during the meeting that he had a plan to access voting machines in Georgia, but Powell said she wasn't aware of the details as to how Giuliani planned to get access to the machines. I think maybe there was an effort by some people to get something out of Georgia, and I don't know what happened with that, and I don't remember whether that was Rudy or other folks, she recalled in her January 6th committee deposition. A few days later, according to the transcript of Giuliani's deposition before the January 6th committee, Powell sent an email to Giuliani, Mark Meadows, and Trump's assistant, Molly Michael. And it said, also be advised, Michigan trip was not set up properly on ground with locals. In other words, a crazy plan that spun out of control because they didn't know what the hell they were doing. And the people who went to Michigan are lunatics. The people who were in Michigan were lunatics. And gosh darn, it just didn't work out that well, as it turns out. Team is there with no access. It has cost us great expense that should be reimbursed by Rudy's funding. Oh, really? Interesting. Georgia machine access promised in meeting Friday night to happen Sunday has not come through. For some reason, people are balking all of a sudden at providing illegally access to voting machines in both Michigan and Coffee County, Georgia. Not really sure what the holdup was in Antrim, where they thought they had a court order, but maybe it hadn't come through yet at this point. Now, when confronted with this email, Giuliani claimed that he could not remember making such a promise during the December 18th meeting at the White House. I mean, he could have been drunk off his ass. That's possible. But it could be a reference, he said, to the January 6th committee. It could be a reference, he said, to the January 6th committee to negotiating with one of the elections boards for access to some of the machines. And probably true, because that's essentially what happened in Coffee County in the end. Giuliani also told January 6th committee investigators that in addition to the court-ordered access they received to inspect Antrim County machines, his team, quote, got access to voting machines, that's all he can say about it, in Coffee County, Georgia. When asked how he got access to the machines in Coffee, Giuliani clarified that he did not personally have access to the machines. The people who had access brought the information to us and demonstrated it to us, he said in his deposition. They came to me, or they came to our lawyer there, who then brought them to me, brought me and showed me their demonstration. So, you know, he kind of second or third hand got this thing. So if these guys were really computer experts, at best what they did was gain unauthorized access to the Coffee County machines, perform some sort of procedure that they said proved something. They showed it to another lawyer working with Giuliani. That lawyer working with Giuliani, who may or may not have any understanding of what the real technical workings are, let alone what these lunatics were telling him was true, then takes it, goes back to, I guess, D.C., and shows Giuliani. And he certainly has no idea. Remember, he's the guy who is accusing the election workers in Atlanta of handing USB ports to one another, let alone in what manner they were doing it. So he's not likely to have interpreted the presentation, the secondhand presentation, all that accurately. But okay, he's told us the chain of custody of this information about the stolen data from Coffee County, that somebody showed it to a guy I know, and that guy showed it to me, and so therefore we know what's going on now. Giuliani further alleged that an expert who had gained access to the machines in Coffee County gave him a report on it. The person who created the report, he said, was probably Phil Waldron, the former Army colonel who was allegedly a primary author of the draft executive order that mentioned voting machines in Coffee County. Attorneys for Giuliani did not respond to requests for comment for this piece. What is the expertise of Phil Waldron? He basically really loves Donald Trump. And he was once in the Army. And so there you go. Section 4 begins here. Even as the Trump team was looking for voluntary access to voting machines, Coffee County officials were eager to share. This is how they hooked up here. Around the time that members of Trump's team holed up in D.C. hotels to draft executive orders to seize voting machines, Kathy Latham, then the chairwoman of the Coffee County GOP, also arrived in the nation's capital. What's she doing there? No one knows. Well, she admitted during her deposition as much that she was in D.C., according to the proceedings in the curling case, one of the earlier mentioned lawsuits. Days earlier, Latham had joined 15 other Republicans in a meeting intended to be secret at the Georgia state capitol, where participants signed alternate, quote-unquote alternate, electoral college certificates that purported to award Georgia's electoral votes to Trump, not Biden. So that would have happened, when they say days earlier, on December 14th, when the real electors actually met. Fulton County prosecutors lay out the circumstances of the fake elector voting in Acts 79 through 82 of the racketeering charge in Count 1. Latham, Sean Still, and others also face separate charges relating to this episode. Count 8 accuses them of impersonating public officers. Those would be members of the Electoral College, I guess. Count 10 accuses them of forgery, because they weren't electors, but they signed certificates that said they were. Count 12 alleges false statements and writings, same things. And count 14 alleges a criminal attempt to file false documents. Why so many counts from pretty much the same act? Well, it violates different statutes, as you can see. For them to pretend they're electors means they're impersonating public officers. For them to prepare those certificates that said that they were electoral votes, that's a forgery. The actual attestations that they would have made to one another that they really were members of the Electoral College, and the forged certificates that they used in the hopes of fooling Mike Pence or someone else into believing they were electors, well, those are false statements and writings. And finally, the fact that they planned to make it look like they were legitimately following the Electoral Count Act by filing those papers with the local federal district court judge, sending them to the National Records, National Archives and Records Administration, sending them to Pence, sending them to all the places that the real electoral votes were supposed to go. Well, that's filing false documents. So you break a lot of laws along the way with that same act, or that same plan anyway. Within days of that meeting, text messages and deposition testimony suggest Latham had made her way to D.C. Why exactly she went to Washington is not entirely clear. I don't know whether she planned on trying to deliver any copies of their votes or what. But at the time, she told at least one source that she was there on matters related to the Coffee County election technology. I'm sure everybody in Washington was waiting for the Coffee County election technology report. On December 17th, Marilyn Marks, the executive director of the Coalition for Good Governance, the election security organization that had initiated the curling suit, texted Latham. Through the election activism grapevine, Marks had heard about the supposed problems with Dominion machines in coffee. She said in an interview with Lawfare, one of the only people that actually answered their questions, I guess, something sounded, quote, suspicious about it all. She said, I would play the dun-dun-dun, but never mind that. She wanted to learn more. She spoke with elections board member Cheney, remember him, Eric, who suggested that she get in touch with Latham. Marks texted the GOP chairwoman explaining that her organization was involved in litigation to move away from the use of Dominion systems in Georgia. Marks asked when Latham might be available to chat, and Latham replied, I'm in D.C. right now, and I'm about to meet with IT guys. I guess that's supposed to make her look more important and officious, and therefore you're barking up the right tree in talking to me. Again, Marks is one of the citizen activists who say, well, we shouldn't be using voting machines at all. That, very frequently they're claiming we need paper ballots and they need to be hand counted everywhere, even though that's impossible, et cetera, et cetera. But people who basically just don't trust voting machines and was suing to get rid of the electronic voting machines. These happen to be made by Dominion. They didn't have any particular I don't think they thought Dominion machines were particularly bad. They just hate all voting machines, as I understand it. Anyway, so she's finding out, now hearing that there are local officials in Coffee County who have partisan reasons for disputing the use of these particular machines. Marks, who opposes maybe all machines and may or may not be partisan in her nature, just says, well, I'll connect with these people and maybe we'll all get what we want as allies against voting machines. And this is why it's a good idea to contact Latham. Now, Latham would later admit under oath that she visited D.C. for an unspecified period sometime in December, but she did not confirm the reason she gave at the time. So that's a problem for her. In her deposition, rather, she claimed that she had traveled to the capital city because she had been invited to go on a, quote, tour by a woman named Juliana Thompson, because Latham hadn't been able to go the previous year. A tour of what? I don't know. We got to see the Christmas trees, and I got to go to the Bible Museum, she explained. There's a Bible Museum in D.C.? All right. I mean, maybe. When asked if she met with anyone who was not with the D.C. tour group, Latham replied, I'm going to plead the fifth on that. Well, I think we know what that probably means. Wink, wink, nudge, nudge. But if Latham was in D.C. only to tour the Museum of the Bible and see Christmas trees, why did she tell Marks that she was, quote, about to meet with IT guys? Right. And Latham did admit in her deposition that she stayed at the Willard Hotel during her trip, which is, you know, it's a real hotel and all, but I mean, there are several hotels in Washington. Why didn't she stay in the Trump Hotel? You might ask that. Why not in any of the other cheaper motels? Why this extraordinarily expensive one where all the other Trump operatives were hanging out? I don't know. But she puts it this way. Well, that's where I slept, she said. That's everybody's first choice. If the Willard Hotel rings a bell, that's because it served as the quote-unquote command center for the legal arm of the Trump campaign, led by Giuliani during the January 6th period of time. The rooms were organized and paid for by Bernie Kerik, the former police commissioner of New York City, who worked for Giuliani and as the legal team, Giuliani's legal team, as an investigator. Kerik later sought reimbursement for the rooms from the Trump campaign, by the way. Another hub and spoke situation. According to his testimony before the select committee, Kerik paid for the room of an unnamed quote-unquote whistleblower from Georgia who traveled to the Willard to meet with Giuliani sometime during the post-election period. The quote-unquote whistleblower, he said, had been brought to the hotel by William Ligon, Ligon, don't know if I'm pronouncing it right, a Georgia state senator and an Atlanta area attorney named Preston Halliburton. Which is just a matrix glitch, if you ask me, but only one L, apparently, in this Halliburton. He did not specifically identify the whistleblower by name. Who might it be? That said, later that month, on December 30th, Latham appeared alongside Giuliani and other Trump surrogates at a legislative hearing chaired by Ligon, whatever his name is, William Ligon, the state senator in Georgia, with Dominion voting systems machines that led Coffee County to refuse to certify its machine recount results. They're having a hearing. These folks show up. They bring one of the machines. Halliburton, who was listed as counsel of record for the Giuliani legal team. Why isn't Giuliani counsel of record for the legal team? Not licensed in Georgia, for one thing, but also didn't really know what he was talking about. And so Halliburton represented Latham at the hearing as well. Latham, in her curling case deposition, denied that she had ever visited the Willard with Halliburton. I'm not certain it's that important that Halliburton be there, the Willard too, but apparently they both were anyway. In other words, while Latham has not admitted that she came to Washington and stayed at the Willard Hotel on Kerik's dime to offer information about Coffee County election machines to the campaign, and while she hasn't admitted that she was the quote-unquote whistleblower of Kerik's account, she did come to Washington. She did stay at the Willard. She did claim whistleblower status at a hearing chaired by the legislator whom Kerik claimed brought a whistleblower to the Willard. And she was represented at that hearing by the same lawyer who allegedly attended the meeting at the Willard with a whistleblower. So it's kind of hard to come to any other conclusion unless we know of anybody else who meets this description, and so far we don't. All we have standing in the way is her pleading the fifth about all of this, but a finder of fact at the trial, like the jury, would be entitled to conclude, I think, that, yeah, she meets all of these criteria. This is who we're talking about. Shortly after her testimony before the Senate subcommittee, the Georgia State Senate subcommittee, Latham received a call from the Atlanta bail bondsman. Why? Scott Hall. He wanted to talk to her about her testimony, Latham said in her deposition during the curling case. Latham, in the same deposition, denied that the two discussed copying any voting equipment during this call. Hall, like Latham, believed that something nefarious had gone on in Georgia during the election. Well, lots of people believe that. And all sorts of things are believed by many people. On November 17th, as Trump's legal team prepared litigation in Georgia, Hall and his wife, Robin, reached out to Lynn Wood, claiming that they had, quote, proof of voter fraud in Fulton County. We watched them count boxes of mail-in votes that were 100% Biden and 0% Trump, Robin wrote in an email to Wood obtained by lawfare. Unlikely, but maybe. On the same day, an attorney named Carlos Silva sent an email to Wood and other lawyers working on Georgia election matters. Just had a long conversation with Scott Hall, as though he were somebody interesting. Silva wrote in an email obtained by lawfare, he seems very knowledgeable when it comes to algorithms and other material information that he has on the Dominion voting systems that was used in this election. I mean, he's a bail bondsman. There's no real reason just from that to expect that he has deep knowledge of algorithms used by Dominion voting system, but people have hobbies and they're sometimes very good at it. I was never Senate parliamentarian, so there's a possibility, right? He may have lots of spare time as a bail bondsman. In another email obtained by lawfare, Silva wrote to Wood and others that he intended to meet Hall the next morning at the office of Ray Smith, an attorney who also was charged in the indictment for alleged crimes related to statements that he made at the Georgia legislative hearings. Later that evening, Hall's affidavit was filed as part of a suit, Wood versus Raffensperger, Lynn Wood versus Brad Raffensperger, which sought to halt certification of the presidential election in Georgia. In his sworn statement, Hall, the bail bondsman, alleged that he had personally observed ballots that, quote, appeared to be pre-printed with the selections already made. Hundreds of ballots at a time were counted for Biden only, he wrote. Hall subsequently became involved with the Trump campaign's post-election efforts in Georgia, although the nature and extent of his involvement remains unclear. On November 20th, David Schaefer, the chair of the Georgia GOP, the state party, penned an email to Sinners, remember the unfortunately named, Robert Sinners and others, in which he described Hall as someone who was, quote, looking into the election on behalf of the president at the request of David Bossie. You remember him, of course. Time for some traffic problems in Fort Lee kind of guy, even though his boss is now anti-Trump, or at least allegedly anti-Trump. This email shows up as Act 4 in Count 1 of the Fulton County indictment. The idea that Mr. Bail Bondsman is working on behalf of the president at the request of David Bossie. I guess anything can happen in this world. Next month, on December 3rd, Hall testified at a hearing before a subcommittee of the Georgia Senate Judiciary Committee alongside Phil Waldron, John Eastman, and Russell Ramsland. By early January, Jeffrey Clark, a little-known Justice Department official who had quickly ascended to Trump's inner circle in the waning days of his presidency and was recently named as an unindicted co-conspirator in Trump's January 6th related federal indictment, had direct contact with Hall, according to the indictment, because Hall had something to tell him about environmental law, apparently, because that was his real job, Jeff Clark. Clark, then the acting Attorney General. Did we know that? Yes, the acting Attorney General for the Justice Department's Civil Division. Oh, yeah, right. He had an acting role, promotion from environmental law chief to a relatively high-ranking job here. The Civil Division, handles all the litigation for the Justice Department, not criminal, obviously. That's the division. There's a criminal division and the civil division, but all legal wranglings in which the government is a party. For instance, if someone is suing about an environmental regulation that they want invalidated, things like that. So Clark, then the acting attorney general for the civil division, had vanishingly little experience with election fraud investigations. That would actually, for the most part, probably be criminal work, too. There's no real reason why the civil division would have a hold of that. But anyway, Trump had taken a liking to him after the two were introduced by Representative Scott Perry, U.S. Congressman Scott Perry of Pennsylvania, in mid-December, according to the January 6th committee report and the federal indictment. Within weeks, Clark was being touted as a potential candidate for Attorney General amid Trump's growing discontent with then acting Attorney General Jeffrey Rosen. On January 2nd, Clark met with Rosen and another Justice Department official, Richard Donahue, we know this from the federal indictment, to urge them to send a letter that he had drafted to state officials in Georgia and other swing states. The draft letter, as you know, implored state officials to call a special legislative session to hear evidence on purported election irregularities. And it recommended that the Georgia legislature consider appointing the alternate, quote-unquote, alternate slate of electors that had submitted electoral college votes for Trump on December 14th. All stemming from, well, they miscounted by 51 votes in Coffee County. But also, we believe tens of thousands of other things that are equally stupid. Anyway, during this conversation, according to Donahue's testimony before the U.S. Senate Judiciary Committee, Clark, quote, began to talk about Georgia and how he had, quote, spoken to this individual in Georgia regarding allegations of election fraud. The unnamed individual in question is described in Donahue's contemporaneous notes, there's those words again, as, quote, the largest bail bondsman in Georgia and owns a phone company. They were not talking about his physical girth or anything like that. Apparently, I guess he's lends out the most money as bail bonds. But he also owns a phone company. And he's really great with algorithms and something else. And maybe, I mean, owning a phone company can mean any number of things. But it made me, these days, it probably means that you do have some certain level of IT expertise and networking expertise. And you might know quite a bit about computer systems, but maybe not voting machines, but, you might have a basis from which to understand things if you made a study of it. According to Donahue, Clark claimed that the Justice Department had good reason to send the letter to state officials, quote, based on a discussion with this individual in Georgia and things that came up in the Georgia Senate hearing. In other words, things that this guy was saying to him and things that this guy was testifying to the state legislature in Georgia. It's the same guy lying to two different sets of people, but it makes it sound like there's, outside confirmation or concurrent confirmation of the same allegations from somebody else when it's really just the same person over and over again. Act 110 of Count 1 of the indictment makes clear that this unnamed bail bondsman was indeed Hall. According to the indictment, Hall, on January 2nd, placed a call to Jeffrey Bossert Clark and discussed the November 3rd, 2020 presidential election in Georgia. The telephone call was 63 minutes duration. Meanwhile, back in Coffee County, a Trump attorney named Catherine Fries, right? There's that name again. What is that? Was it Foster? Oh, it was like Foster Fries when he said, I think, right? They said Fries when we pronounce his name. So maybe it's Catherine Fries, messaged an employee of the Atlanta-based forensic firm Sullivan Strickler on January 1st. I don't know that there's any real relationship between Catherine and Foster. I think Foster, wasn't he from like the northern tier states, right? And she's working down in Georgia, so I don't know. Maybe she's not native to Georgia. Anyway, the messaged an employee from Fries to Sullivan Strickler on January 1st, and it says, "Hi!" exclamation point. Just handed sick back in D.C. She means landed then, I guess. Landed back in D.C. with the mayor, Giuliani. She said, huge things starting to come together. Most immediately, we were granted access by written invitation, exclamation point, to the Coffee County systems. She means systems. Yay! This is a weird person. A little too excited. Putting details together now with Phil, Preston, Jovan, etc. Want to give you a heads up for your team. Will be either Saturday or Sunday this weekend. More soon. And then smiley face emoji. Not the emoji, but the old emoticon. Not emoji, right? Okay. So anyway, a little too excited about that, but, and mischaracterizing what's going on. Or, well, maybe it doesn't mischaracterize things to say they were given a written invitation to Coffee County's systems, but the authorization for the invitation doesn't exist. That's important. The same day, according to a privilege log produced in a defamation case brought against Giuliani, Fries sent a letter of invite from Coffee County, Georgia, to Waldron, Carrick, and Todd Sanders. A letter of invitation was never produced to the plaintiffs in the curling litigation, interestingly, and in an interview with Lawfare, Marks said that open records requests for such a letter produced no responsive documents. Maybe there was no letter. If such a letter does exist, its authority remains illusory. In a deposition in curling, a representative for the Coffee County Board of Elections says that the board neither knew about or authorized the operations carried out in January of 2021. Could just be covering their ass, but that's what they're saying. The Secretary of State's office has publicly referred to the incident as, quote, unauthorized access to the equipment that former Coffee County election officials allowed in violation of state law. The indictment does not refer to a letter. It does, in Act 134 of Count 1, allege that on January 6th, Latham called Hall and Hall called back. During at least one of the phone calls, they discussed Scott Graham Hall's request to assist with the unlawful breach of elections equipment at the Coffee County Board of Elections and Registration Office in Coffee County, Georgia. The bail bondsman wants to get in on the action and commit some crimes himself. In her deposition in the curling litigation, Hampton claimed that Cheney, a member of the board, had directed her to allow the copying of the election systems. But Cheney would not have had lawful authority to unilaterally direct Hampton to do so, as decisions of the board require a quorum, according to the deposition testimony of the current chair of the Coffee County Elections Board, Wendell Stone, who's not in trouble, it turns out. In that deposition, Stone also said that the board as an institution had no knowledge of the breach. No relation, probably, to Roger Stone. All right, welcome back now to the Kagro in the Morning Show here on Netroots Radio. We're still going with this lawfare article. I better get through it if I want to get to all the other stuff. We may be in trouble. Okay, where we left off. Well, okay, so now we have different members of the Coffee County Board of Elections insisting that other people were the ones responsible for giving Scott Hall and others access to the voting machines. But apparently, even if Eric Cheney would claim that he did do this, and he initially did not. He initially denied it. He doesn't have the authority. No one member of the Coffee County Board of Elections can just say, sure, go ahead and copy all the software on the machines. There would have to be an act of the board. There would have to be a quorum present. There would be, a real record of it. And there just isn't any record of anything like that. But, who is it that says this? Hall? Let's see. Was it Hall that says that Cheney did it? No, in the curling litigation, Hampton, Missy, claimed that Eric Cheney, a member of the board, had directed her to allow the copying, but Cheney wouldn't have had the authority to do that anyway. As details of the breach began to emerge last spring, Cheney initially denied involvement in allegedly unauthorized access to the election equipment. I do not know Scott Hall, and to my knowledge, I am not aware, nor was I present in the Coffee County Board of Elections office when anyone illegally accessed the server or the rooms in which it is contained. He wrote in April of last year, according to a court filing. When asked in his deposition if he authorized access to the elections office, Cheney didn't say no. He invoked his Fifth Amendment right against self-incrimination. Cheney did not respond to requests for comment. So that, again, sounding like he actually did do that. But when he thought he could get away with saying, no, I didn't do it, he tried that. When he found himself on the hook for a possible indictment, and now the indictment is real, he invoked the fifth. At 4:17 p.m. on January 6th, 2021, that's late in the day, on January 6th, the President of the United States belatedly tweeted out his video message to the mob that had forcibly disrupted the counting of the electoral votes. "You have to go home now," he finally said. This is, by the way, Section 5. We're moving on to the next phase of the story here. But even as Giuliani was keeping up pressure on senators to, quote, slow it down, Coffee County officials were undeterred. What are they slowing down? Remember, yes, they're sending the mob home, finally. But at the same time, they're still contacting senators. We know, like, for instance, Giuliani was frantically trying to reach Tommy Tuberville, the brand newly minted senator from Alabama, who was just as dumb and crazy as the rest of them, and so therefore might, in his first days in office, I think, right, be willing to throw himself across the train tracks and try to further derail the counting of the electoral votes. Now that the mob was going to go home and they could possibly, start thinking about, well, when are we going to get people back on the floor and counting? He's trying to reach other senators and say, well, if they do manage to get back in there, you need to use procedure to try to slow them down or stop them. In the weird belief that if they push things at least to January 7th, that would have some legal significance. Or at the very least, if they just continued to delay and maybe frustrated everybody so much that they said, well, just to make some move forward, let's send some things to the states, just so that there's some motion going on here. Maybe that was their thinking. Anyway, 9 minutes after the president's tweet at 4:26 p.m. that afternoon, Hampton sent a text to Cheney. Scott Hall is on the phone with Kathy about wanting to come scan our ballots from the general election, like we talked about the other day, she wrote. The next morning, on January 7th, Latham texted Hampton to tell her that the Sullivan-Strickler forensics team had departed Atlanta and were on their way to Coffee County. Hall, she added, was flying in, too. Yay! With 1, 2, 3, 4 exclamation points. Hampton responded. These events are also mentioned in Acts 142 and 143 of Count 1 in the Fulton County indictment. Several minutes later, Paul Maggio, the chief operations officer of Sullivan-Strickler, sent an email to Powell, Logan, Penrose, and others. We are on our way to Coffee County, Georgia, to collect what we can from the election/voting machines and systems, he wrote, attaching an invoice for Sullivan-Strickler's $26,000 retainer fee. The invoice billed Powell's PAC, Defending the Republic. Poorly named since it was undermining and attacking the Republic. Minutes later, Maggio also texted Latham, instructing her to have Eddie, whoever that is, pick up Hall at the local municipal airport. Eddie here being an apparent reference to Voiles. Remember that name from yesterday? Last summer, during a deposition in the curling litigation, Latham claimed that she arrived at the elections office sometime after 4 p.m. She stayed for, quote, just a few minutes. She replied when queried about how long she stayed inside. Latham also stated that she only spoke to Hall outside the office for, quote, 5 minutes. The indictment alleges, flatly, in Act 160 of Count 1, that Latham was lying on these and other points. And surveillance video from January 7th paints a different picture from her testimony, according to court records. A timeline of the surveillance video created by the law firm Morrison and Forster on behalf of the curling plaintiffs states that Latham arrived at the elections office shortly before noon, not 4. She then waited outside for Hall and the Sullivan-Strickler team, escorted them into the building after they arrived. Escorting them in. Once inside, she introduced Hall and the forensics team to Hampton, Cheney, and Voiles. The footage shows that Latham ultimately spent more than 4 hours inside the office, as Sullivan-Strickler employees created forensic copies of virtually every piece of Coffee County's elections equipment, including the election management system, or EMS, server, the poll pads, the ballot marking devices, and the ballot scanner, according to court documents. How long did you talk to Hall? 5 minutes. Were you ever inside the building? Only for a fleeting few minutes. Okay, the security footage shows you in there for 4 hours. Do you have any reason why you might have stated to us before there was only a few minutes and when it was actually a couple hours? No. Is that absolutely necessary to know? Is it dispositive of anything? No, but it is dispositive that her recollection of what happened is at the minimum, that is unclear. And at worst, that she's lying for some reason to investigators, and maybe they can piece that together. That afternoon, Maggio emailed Powell, "Everything is going well here in Coffee County, Georgia," he said, before asking for confirmation of payment. He knows very well he's dealing with Trump people, and you got to make sure you're getting paid. According to court filings, the forensics team left the elections office around 8 p.m. that evening, well past the usual hours open to the public. In Powell's January 6th committee testimony, she downplayed any alleged role she played in efforts to gain access to the voting machines, because she knows now it's illegal. "I think I was asked to pay expenses of some of those trips in some way. Some of the teams of cyber people that were going to look for them," she said. "I didn't have any role in really setting them up or making sure how they were done that I remember." She just forked over $26,000 for no good reason. Remember, she was complaining about the expenses that were mounting in Michigan. So expenses were important to her, but she's just handing out $26,000 checks left and right out of her PAC. Maybe she doesn't care so much about spending the PAC money, but I didn't have anything to do with it. I only arranged it and paid for it. Yeah. Again, the indictment claims otherwise. Shortly after the forensics team departed, Cheney sent Hampton a text containing the cell phone numbers of Sinners, the campaign staffer for Trump, to whom the two had spoke back in November. "Let's switch to Signal," Cheney added, referring to the encrypted messaging service. No real reason we want to do that, though. Just for fun. In his deposition, Sinners denied that anyone had gotten in touch with him about the events in Coffee County. He testified that he had no knowledge of the copying of voting equipment until he learned about it in media reports. "This was well beyond the time that I had disengaged from, the Trump campaign operations," Sinners said. Shortly after the events in question, Sinners went to work for the Georgia Secretary of State's office. Last year, he cooperated as a witness for the House Select Committee investigating the events of January 6th. Sinners denied involvement with plans to access voting equipment in Coffee County. It's interesting that he went to work for the Georgia Secretary of State's office, because the Georgia Secretary of State's office, famously in all this, is set apart as doing the right thing and standing as a bulwark for the rule of law and democracy in all of this. And it's now alleged that one of the people that's indicted in Fulton County's indictment was originally connected with the Trump campaign and then moved to the Georgia Secretary of State's office. And apparently he's tied up in this whole unauthorized access to Coffee County's machines from inside the Georgia Secretary of State's office. Again, the bulwark standing, athwart Trump's preferred history and or a future, I guess, at that point, and saying no and standing up for the rule of law. It's interesting that this guy has been on both sides of this fence. Well, let's see. So Sinners denied involvement with the plans to access the voting equipment. "If your article is factual, then it will be clear I wasn't involved," he told Lawfare when contacted for comment. Asked if he is cooperating with prosecutors in the Fulton County case, Sinners replied, "I'm not sharing any particulars regarding my own experience at this time. My previous statements should indicate how I feel on Trump's failure of leadership and the need to speak fully and truthfully to anyone who asks." Cheney, for his part, pleaded the fifth more than 200 times in his deposition, including when asked if he communicated with Sinners about the copying. The next day, on January 8th, Maggio again emailed Powell. Quote, "Everything went smoothly yesterday with the Coffee County collection," he wrote. "Everyone involved was extremely helpful. We are consolidating all of the data collected and will be uploading it to our secure site for access by your team. Hopefully we can take care of payment today." He's still with the payment thing. And by the way, that's interesting. Hopefully we can take care of payment. I thought, he emailed her twice the day he went to confirm payment. So I guess the fact that he's emailing again the subsequent day means that he was unable to confirm payment. Which, again, that's the one smart thing anybody is doing here. Later that month, video surveillance shows that Hampton again permitted outside access to election equipment. Shortly before 5 p.m. on January 18th, Hampton arrived at the elections office alongside Logan, the CEO of the Cyber Ninja security firm, and Jeff Lenberg, not Bill Lumberg, but Jeff Lenberg, a forensic consultant. At the time, the office was closed to the public in observance of Martin Luther King Jr. Day. But the surveillance footage shows that the trio spent more than 4 hours inside the office, according to court filings. And what better day to try to invalidate the votes of millions of black Americans? Anyway, the next day, according to court documents, the surveillance video shows that Logan and Lenberg returned and spent most of the day in the elections office. At one point, while Logan and Lenberg were allegedly in the building, Hampton texted Cheney, "The guys measuring my desk are still here," she wrote. I'm not even sure what the heck that's supposed to mean, but that's what she said. Over the course of the month, Lenberg made additional visits to the elections office, where the footage shows that he spent time in the room that holds the election management system server, where nobody is supposed to be. In respective depositions, both Lenberg and Logan claimed that they were invited to assist Hampton with tests on the voting equipment after she complained of, quote, anomalies during the Senate runoff held in January. They believed Hampton had authority to authorize the assistance they provided, the men said, and according to Lenberg, neither he nor Logan touched any of the voting equipment. Instead, they directed Hampton to conduct certain tests, which might be a good legal dodge, but not necessarily a great way of conducting forensic testing. We're the experts. Yes, we know how to conduct this testing. Did you conduct it? No, we actually just made somebody else do it instead. Why? Because we believed that she had the authority to do it. I know, but she also invited you to do it, you said. Yes, but I guess at some level we didn't really believe that she had the authority to do that. So in order to duck responsibility, we made her handle it. Is that what they're saying? I guess so. A month later, on February 25th, Hampton resigned from her position, weirdly, as elections supervisor. According to deposition testimony, she signed a letter stating that she had resigned to avoid termination, purportedly on the basis that she fudged her timesheets, which, she might also have been doing alongside this other illegal activity. Maybe it was a cover-up of her illegal activity. Don't know. But I guess somebody threatened to fire her, or at least she wanted to make it look like someone was threatening to fire her. That's why she wanted to skip town, essentially, get out from the role she had played to this point. That evening, a private jet owned by Mike Lindell, the pillow guy, a prominent election conspiracy theorist, Trump confidant, and founder of MyPillow, appeared on the tarmac at the Douglas Municipal Airport in Coffee County, according to Hampton's deposition transcript. It just appeared from out of nowhere. It probably flew there, is my guess. The plane had been in Palm Beach, Florida, weirdly enough, earlier that day. It stayed in Douglas for about 2 hours before departing. I see what they're getting at now. Nobody gets off, nobody gets on, or maybe no one leaves. They might board. I don't know. I guess we should just read on before trying to guess what's going on here. But tarmac, appearing on the tarmac. It's a weird way of describing what's going on here. Lindell previously told the Washington Post that he was there to meet with entrepreneurs about cooling towels that entrepreneurs were pitching to MyPillow. It just so happens that these entrepreneurs were Coffee County, Georgia based. I guess, if true, that would be, I didn't have anything to do with this, but if anybody believes that, then, they should speak up, because I don't hear anybody saying, that was likely what was happening. They didn't do it by phone. Of course not. Or by Zoom, for that matter. Within 2 months, Hampton was hired to run a special election in another rural county in Georgia. Treutlen County? I don't know how you pronounce this. Treutlen. Treutlen? I don't know. This April, 11 Alive. It's weird how there are different TV stations around the country they're Channel 11. Is that a chain or something? They all call themselves 11 Alive. They had one in New York. They got one down in Georgia. But anyway, this April, the one in Georgia reported that investigators for the Secretary of State's office had seized the elections server in Treutlen County to check for possible, quote, security compromises after discovering that Hampton supervised the special election there. So that was wise of them to do, I think. Basically, they think anywhere that Missy Hampton shows up, there's the possibility that elections machines have been tampered with, because weirdly, she keeps inviting these unauthorized forensics experts in to tamper with machines. And she apparently, according to their testimony, did the testing, whatever that's supposed to be, the manipulation of the machines. She did it herself with her own 2 hands. Then she resigns and then moves to another county and administers elections there. And now the state Secretary of State's office is basically suspicious of any of the voting machines, the integrity of the voting machines wherever she's working. That's pretty interesting. It remains unclear what the Secretary of State's office was investigating or why it seized that county, Treutlen's county servers. The events in Coffee County may have a long tail. By making voting systems and voter data available, they have potentially made these systems less secure. That issue will still need to be addressed. The indictment, however, at least shows that you can't, as county officials or a political campaign, just go in and take the stuff without someone noticing and without accompanying legal risk. If you breach election systems to prevent supposed voter fraud, you risk being charged with attempting voter fraud yourself. Yes, that the final point of this very lengthy article, and the point is twofold. One, no, you can't just walk in there and do whatever you want, even if you're a elections board official, and you can't make other people do it or have them instruct you how to do it and thereby avoid any liability for that. But no, you're not allowed to just do this investigation on your own. Secondly, every Republican accusation is a confession, I guess I would say. Maybe the point is more than just twofold. Third, yes, there's every possibility that your manipulation of the machines, even if you claim you did it because you were looking for somebody else's manipulation of the machines, by however you slice it, these machines have now been manipulated without sufficient authority and possibly expertise, and they're now therefore compromised. And it turns out that if you were full of it, or just completely wrong about the accusations you made about the other side, now the machines have still been manipulated and are now corrupted, and you did it. You may have been well-meaning in your mind, but fact remains, these machines have now been accessed without authorization and are now corrupted, and it's your fault. No matter what you thought you were after, you did it in the end. And then the last point is that, yes, your accusation was that some other nefarious figure had at some earlier point also accessed the machines and manipulated them in some way. Maybe not in the custody of Coffee County, maybe at the original place of manufacture, whatever it is. But as it turns out, it seems extraordinarily difficult to access these machines, do whatever it is you think was being done to them, and then get away with it without leaving a trail of evidence. In other words, either it was ghosts that manipulated the machines before you did, and that's why they don't appear on the surveillance video, or it never happened, and that's why it never appeared on anybody's surveillance video. Because when you did it, you left an imprint on surveillance video. Here it is. You can't produce it for anyone else, but we can produce it for you. Maybe you were a total idiot. Maybe it never happened, and the only unauthorized access to the machines and manipulation of those machines was at your hands. Now we seem to be getting somewhere. All right, lengthy article, as I said. Well worth the time, I think, just because it helps explain, well, what is this whole thing? I mean, we understand why it's a part of the indictment in Fulton County, and it's an important part. But while I think we all understand the mechanics and supposed justification of the fake electors scheme and the various other lies about insisting that there was election interference, what we didn't really have any information about was exactly what all of these other idiots in Coffee County, Georgia were doing, why Coffee County, what they did, the machinations they went through to try to avoid taking responsibility for doing this thing, and then how it fits into the conspiracy in the end. I mean, they were always apparently plugged into the DC hub for all of this. And at some point, there are people down there running around saying that they're acting on behalf of the president at the direction of one of his top aides. So there you go. Hub and spoke. Okay. Other things that I wanted to share with you, and there are many. Let's see. How about this? Since we've been speaking about yesterday we checked in. Was it yesterday that we checked in with Rosalyn MacGregor about the Antrim County situation? Well, not the Antrim County situation, but the state situation in Michigan. naming the various electors, the fraudulent electors, who they were and why they were in trouble and what their names were and exactly how they got themselves wrapped up in this thing. Now, getting local again, just to sort of switch gears and as a palate cleanser, we'll talk about the situation in, are we back in Ottawa County at this point? Let me roll her latest installment on local politics, just sort of basically telling you this. I guess the Republican Party, I guess when you slice it down to narrower tranches, still produces the same sort of shenanigans top to bottom, like fractals. Doesn't matter how small the slice is, the pattern is the same. So let me roll that before we exit this segment of today's show. Take it away, Rosalyn.
Good morning, David. Your listeners may remember my reports about Ottawa County, Michigan, and the Ottawa Impact Radicals who took over the County Board of Commissioners in January.
Yes, you were
The county chair, Joe Moss, even went so far as to file an amicus brief in the recent SCOTUS decision about the web designer who didn't want to code sites for those fictional LGBTQ clients. Listeners may remember that the professional county administrator was forced out and a Trump flunky from HUD who was praised as overqualified for the position was hired in his place. John Gibbs also ran an unsuccessful campaign for a congressional seat where his past statements that women should not have the right to vote came to light. John Gibbs and one of the Republican commissioners got into a confrontation over lack of communication from Gibbs about the possibly illegal firing of the county health director, which resulted in a majority of the board approving sanctions against that commissioner. Then the deputy county administrator resigned, citing, quote, deep concern regarding what I have viewed to be a lack of effective leadership and an eroding culture of employee trust and support within the county, unquote. He also said he had been uninvited from key departmental meetings and received limited to no communication from Gibbs. He also cited concerns over Gibbs not adhering to county hiring policies. Back in March, Gibbs asked the county commission that an additional $37,000 be added to the salary for an administrative assistant after Gibbs said he needed more help doing his job running the county. It wasn't until the August 8th board meeting that Gibbs announced he'd hired someone. Then he refused to say who would be earning the $81,538 salary. For those keeping score, the job will cost the county $132,218.89 with benefits. When Gibbs was asked by Commissioner Jacob Bonema who the new hire is, Gibbs declined to tell the board, quote, I'm not going to get into it now, Gibbs said. I don't want it to be a public spectacle, unquote. Well, there was good reason not to share the name as the pond keeps getting slimier. It turns out Gibbs hired Jordan Epperson, who is set to start on August 21st. Jordan Epperson is currently listed as the legislative aide for State Representative Neil Frisk, a conservative Republican from Charlevoix. Frisk is part of the ultra-conservative Michigan House Freedom Caucus and serves as the legislative liaison for Michigan GOP Chair Christina Caramo. Caramo, you may remember, was nominated to that Michigan GOP chair by Joe Moss, Ottawa County chair. In November 2020, Epperson tweeted, quote, in Michigan, we starved through an 8-month lockdown, saw our businesses die, and witnessed families falling apart. All part of the plan to initiate mail-in fraud and steal the election from Donald Trump, unquote. And then stated Governor Gretchen Whitmer and Secretary of State Jocelyn Benson belong in jail. Despite being, quote, overqualified, unquote, Gibbs said he needed this new position as a chief of staff type role who will help him take notes at meetings, organize follow-up meetings, and catalog everyone he meets. While Ottawa County pays more for another political hack, they also are paying more for legal fees because of the law firm the Ottawa Impact Commissioners approved. Payments to Kalman Legal Group have gone over its expected budget, requiring county leaders to set aside $110,000 more for the firm. When Kalman Legal Group was hired, it was estimated the firm would bill the county about $23,400 a month for its services. However, invoices have been averaging around $35,000 a month, putting the bill at about $210,000 for the first 6 months. On a side note, the 2024 county budget being discussed now asks for $430,000 for legal fees. Chairman Moss blamed the increased invoices on a rising number of Freedom of Information Act requests being processed by Kalman, as well as the need for legal representation in lawsuits levied against the new board. Specifically, that means the lawsuits from the county board possibly illegally firing the county's health director and putting an unqualified HVAC professional in that position. Also, there's an appeal in the courts over a recall effort for unseating one of the Ottawa Impact commissioners. This proves yet again that GOP radicals don't want to govern, and they certainly aren't being fiscally responsible. That's my time for today. This is Rosalyn MacGregor signing off. Back to you, David.
Hi, everybody. It's me, David Waldman. Yes, the same guy who interrupts you all the time. Interrupting you one more time just to tell you again, another reminder that your contributions are what keep this show on the air, and Patreon.com, Patreon.com, is still among the easiest ways to make the sustaining subscription donations that keep us afloat. Are you ready for the pep talk about how our Patreon campaign is still going strong and growing? Well, too bad. Yeah, the plain fact is we actually are headed in the wrong direction, and whereas we once had about 175 monthly patrons, we're now actually down below 150. Time to recruit some more. Not exactly the kind of news I wanted to share, but there it is. For those of you in a position to support the show, Patreon.com does make it easy to make those secure, recurring monthly contributions to do so. Patreon.com/KagroX gets you straight to our donation page. We've been through a lot together. The worst of the pandemic, we hope. The worst of the insurrection, we hope. So go ahead and treat yourself. You don't need an excuse. Give yourself the gift of a little something you enjoy in life. Support the show. And of course, if you happen to prefer using PayPal or even the Square Cash app, we're up and running on those options too. So thanks again, everyone, for all your support. We couldn't, or at least shouldn't, do it without you. Hope you'll be on board soon too. Thanks for all your support. All right, welcome back now to the Kagro in the Morning Show here on Roots Radio. They screwed everything up here, of course. This one ran a little bit longer than I thought, and the brake noise, the brake alarm went off, and right in the middle of Rosalyn's conclusion there, and I hope it wasn't cut off too badly, but in post-production, we'll fix it for the podcast. I guess I should have written down somewhere exactly what the run time was on that. But we thank you, Rosalyn. I'm sorry we stepped on your conclusion as well, but thank you for bringing us back up to date on the lunatics operating in Ottawa County, Michigan. And all right, we're going to jump back to the national picture here. I guess I just should have saved that segment for the last section of the show, but instead we'll hop around and pick up on some other things. The latest news to make it all the way into Pocket, and that's the ultimate filter of all news of importance, really, honestly, is this, which was circulating this morning thanks to CNN and Andrew Kaczynski, but also, let's see, he's got M. Steck and, oh boy, I have a name to look at this one. I haven't run into this one yet. Yahya, I guess, Yahya, Yahya Abu Ghazala. I apologize for not getting that one right, but I guess maybe this person brand new to CNN, because everybody else has a picture up by the byline, and this year we just have the CNN logo for the last name there. But okay, what's the story here? Let's get to the substance of it. Let's see, title perhaps. Headline, Kenneth Chesebro, alleged architect of fake electors plot, followed Alex Jones around the Capitol grounds on January 6th. Seems like an awfully weird thing to be doing with your elite legal team strike force that day, but I don't know. I guess it just demonstrates some strange interest in Alex Jones type activity for the supposedly anomalous Kenneth Chesebro, once trained with, well, who are we talking about here? With the liberal lions in his law school days. But now I'm blanking on who it was he was working with. But, well, we can remind ourselves by jumping back to that weird profile of Chesebro, if that will help. Anyway, what's happening here? When conspiracy theorist Alex Jones marched his way to the U.S. Capitol on January 6th, riling up his legion of supporters, an unassuming middle-aged man in a Trump 2020 hat conspicuously tagged along. Videos and photographs reviewed by CNN show the man dutifully recording Jones with his phone as the bombastic media personality ascended to the restricted area of the Capitol grounds, where mobs of then-President Donald Trump's supporters eventually broke in. While the man's actions outside the Capitol that day have drawn little scrutiny, his alleged connections to a plot to overthrow the 2020 election have recently come into sharp focus. He is attorney Kenneth Chesebro, the alleged architect of the scheme to subvert the 2020 Electoral College process by using fake, fraudulent GOP electors in multiple states. When asked by the House Select Committee where he was the first week of January of 2021 and on January 6th, Chesebro invoked his Fifth Amendment rights. But a CNN investigation has placed him outside the Capitol at the same time as his alleged plot to keep Trump in office unraveled inside it. So that connects into another spoke of the conspiracy. He might be a hub himself. There is no indication Chesebro entered the Capitol building or was violent. Doesn't matter, of course, because if he's connected to the conspiracy, I wonder if you might have been able to connect him to some of the violent activity there after all, but they didn't bother to do that so far. Anyway, he says, or there's no indication that he did anything like that day. Jones did not enter the Capitol on January 6th either, or engage in violence, but he had warned of a coming battle the day before and urged his supporters to converge on the Capitol. Chesebro is only one of the unindicted co-conspirators in Trump's recent federal indictment, and the only member of Trump's legal efforts who is known to have been on the Capitol grounds on January 6th. CNN was able to place Chesebro at the protest through publicly available databases with photos and videos from that day. Interviews with his acquaintances also confirmed his identity. Chesebro declined CNN's request for comment, citing ongoing litigation. It's unclear why he was following Jones on January 6th. Even if Chesebro is simply a diehard InfoWars fan, I think it would further illustrate how thin the line was between the serious, credentialed people who sought to undermine election results and the extremist figures who sought to unleash havoc. How thin that line was in that period, to the extent it meaningfully existed at all, said Jared Holt, an expert at the Institute for Strategic Dialogue, which investigates extremism, hate, and disinformation. Until 2022, the extent of Chesebro's involvement in the alleged plot to subvert the election was relatively unknown. The Harvard-educated attorney is now indicted in Fulton County, Georgia, along with Trump and 17 others, with prosecutors alleging they were involved in a criminal conspiracy to unlawfully change the outcome of the election in Georgia in favor of Trump and elsewhere. Chesebro's path to Trump's orbit was untraditional. He is a former research assistant of, here's the answer, Harvard professor Lawrence Tribe, one of the nation's most esteemed liberal constitutional scholars. Chesebro reportedly said he made a small fortune in cryptocurrency. Maybe that's what turned him crazy. And by 2020 was donating thousands to Republican candidates. In November 2020, he began his work advising the Trump campaign attorney Jim Trupis on the potential to use fake electors in Wisconsin, first reported by the New York Times. Chesebro later wrote a series of memos that outlined plans in which fake Trump electors in states won by Biden might be recognized by a court, the state legislature, or Congress. In a December 2020 email exchange between Chesebro and John Eastman, another architect of the fake electors scheme, discovered by the House Select Committee investigating January 6th, Chesebro suggested that chaos on January 6th could pressure Supreme Court justices to act before the count could occur. He wrote, "The odds of action before January 6th will become more favorable if the justices start to fear that there will be wild chaos on January 6th, unless they rule by then, either way." Interesting that he both warns that would be helpful to them and then shows up on January 6th to observe that it actually occurs. Of course, he could point to it and say, well, I said that it would be important before January 6th, but the goalposts keep moving with these guys, so who knows? In Trump's recent federal indictment, Chesebro was identified by CNN and everybody else as co-conspirator number 5, described by prosecutors as an attorney, quote, who assisted in devising and attempting to implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding. Now, what went on at the Capitol? On January 6th, photos and videos show Chesebro with Jones for about an hour, starting a short distance from the Capitol around 1:40 p.m. As Jones and his entourage make their way to the Capitol, Chesebro followed with his phone out, seemingly recording Jones. CNN recreated Chesebro's movements using deleted video clips from the conservative social media site Parler, photos from Twitter, footage from InfoWars, and video from Jones's own bodyguard body camera, previously published by InfoWars, along with video compiled by amateur researchers who tracked Jones's movement. Videos reviewed by CNN show Chesebro with Jones in 2 sections of the restricted area around the Capitol, cited in a federal indictment against Owen Schroyer, another InfoWars host who was with Jones in those areas at the same time as Chesebro. Schroyer, who had previously signed a deferred prosecution agreement in another case, saying he would not engage in disorderly conduct on the Capitol grounds, was charged with 4 misdemeanors. Schroyer later pleaded guilty to 1 misdemeanor count of entering and remaining on the restricted grounds. Ryan Goodman, a law professor at NYU, who previously served as special counsel to the General Counsel at the Department of Defense, told CNN that Chesebro's presence on the Capitol grounds could be cited by prosecutors. Regardless of Chesebro's potential criminal liability for being in a restricted area on the Capitol grounds, this evidence could be cited by prosecutors as further proof that Chesebro was not operating as a bona fide legal advisor, but rather was an activist aligned in the cause to overturn the election, Goodman said. It undercuts defenses Chesebro might mount that he was functioning only in the role of providing legal advice for clients. Footage shows Chesebro front and center, recording Jones as he gives an impromptu speech on the west lawn of the Capitol grounds, urging supporters not to fight police and make their way to the other side of the Capitol where they have a permit. As Alex Jones and his entourage leave, the west side of the Capitol is breached. Chesebro follows Jones and his entourage to the other side of the Capitol and at one point appears to show something on his phone to a member of Jones's security team at approximately 2:09 p.m., one recording shows. Later, the group, including Chesebro, make their way halfway up the steps of the Capitol building before heading down. Shortly after they leave, a mob trying to force the doors of the east side of the Capitol would push their way through. Chesebro follows members of the group as they depart the Capitol grounds close to 3 p.m. Later, Chesebro can be seen walking near the Peace Monument in front of the Capitol. Ironically enough, in a deposition with the January 6th committee in October of 2022, Chesebro invoked his Fifth Amendment right against self-incrimination when asked if he had been in Washington, D.C. in January 2021, leading up to the certification of the results. An email obtained by the committee shows Chesebro saying he would be staying at the Trump International Hotel in D.C. from the 3rd to the 8th of January. For some strange reason. A video reviewed by CNN shows Chesebro at Freedom Plaza a day earlier, on January 5th, ahead of a rally that also included speeches from Jones and Schroyer. Okay, so an interesting new development, not entirely incriminating all by itself, except for the fact that, it explains why he was invoking his Fifth Amendment rights in some cases, and of course shows him in a place where he could at least be convicted of a misdemeanor of entering and remaining in a restricted area. Just thought I'd throw that one out there. Other stories that I wanted to acknowledge and get on the record before perhaps piling on some more on TFG's legal travails. We mentioned to the other day, I think we made mention on the air, but if we didn't, well, we certainly meant to, but I think we just tried to squeeze it in and say, I acknowledge that this has happened, but we can now revisit the weird ruling in the Southwest Airlines case in which a federal judge? I think so. A federal judge had ordered Southwest Airlines attorneys to undergo a sort of religious freedom sensitivity training for some reason. They were being sued by employees of Southwest over, accusations that Southwest Airlines had violated their religious freedoms in some way. And I forget the particulars of it, but perhaps this story will help explain it. And I guess the judge felt that Southwest's attorneys defending them from the suit were insufficiently were showing insufficient deference to and recognition of what were alleged to be, serious and substantial claims that someone's religious liberties had been violated because they didn't believe it. They were defending the suit. And so along the way, the attorneys would be forced to undergo this religious tolerance sensitivity training. But oddly, it would be administered by a group which is, one thing wrapped up in a number of things, a number of bits of litigation around the country that sort of demonstrate that they're actually something of a right-wing extremist group, and two, are themselves awfully intolerant professionally of LGBTQ community members. And maybe they need some sensitivity training themselves. And then the weird thing of, why would there be an order to undergo this sort of training, for one thing? And why would there be an order that it be conducted by this partisan political group of operatives? And it reminded me in a weird way of, we kind of allow this to happen all the time. It's probably wrong to do so, but I'm just thinking of all the statutes around the country that were adopted by state legislatures mandating that gun training, for instance, where it's mandated in pursuit of a permit or anything else of the sort, that the training be provided by the NRA or NRA certified trainers. And why are they given an official role in all of this? And I think it stems back to the day when the NRA actually had more of a role in, safety training than anything else, but then became a political advocacy group. Well, Chris Geidner is explaining what's going on here, and you can always turn to him for good coverage of these things. And there's some good news. The headline gives it to us that the judge halts the religious liberty training, which Chris encloses in scare quotes here, halts his own order, as Southwest argues that it's unconstitutional. Well, good. But it's another piece of information that, once again, we do find that occasionally we hear that, the thing we have to worry about is these Trump judges don't care at all about being reversed or what the state of the law is. Sometimes they're just going to do what they feel like doing. But occasionally we do see stories like this where we say, well, the judge's, the initial decision was stupid, and maybe he thought he would get away with it if there wasn't an outcry. But there was an outcry, and I guess, sort of, kind of, to his credit, minimal credit awarded here, he said, yeah, maybe that was kind of crazy and we should slow things down. Subheader tells us the airline is also arguing that sanctions go beyond civil contempt powers. U.S. District Judge Brantley Starr has put the sanctions on hold for 30 days. Here's the story, if we can run through it quickly. The religious liberty training, quote unquote, ordered by a federal judge earlier this month as part of a contempt order in a religious discrimination case brought against Southwest Airlines, is on hold for now under a temporary order issued by the judge on Thursday. That's yesterday. Lawyers for Southwest Airlines are appealing the sanctions order, and on Wednesday argued to U.S. District Court Brantley Starr, a U.S. Court judge, district judge, the judge who issued it, that those sanctions are unconstitutional and go beyond the court's contempt powers, which are usually pretty broad. Whoops, I got to get rid of this. Jumping back. I got sucked into the subscription routine here. But everybody should go subscribe to Chris's newsletter, I guess. They did so, the attorneys did, as a part of a request that the judge put the sanctions order on hold while they appeal it. And he said, yeah. So good news there. In response, Starr issued an administrative stay on Thursday that will last for 30 days while he considers the airline's request for a stay of the order pending its appeal to the U.S. Court of Appeals for the Fifth Circuit. Not a great place to be, but it's an appeal nonetheless. The temporary stay means the lawyers will not need to attend the religious liberty training, quote unquote, run by who? The Alliance Defending Freedom. That may ring a bell for you because, one, they've been involved in lots of anti-LGBTQ litigation around the country. And two, I believe they have a thread that connects them to, the Chris Rufo wing and Loudoun County's problems and Florida's problems and the new college problems down there. These people are at the nexus of their own hub and spoke conspiracy that would be could be illustrated if you really put a mind to it at some point. So the ADF, for some reason, the Alliance Defending Freedom, which is like a legal litigation group, how are they qualified to provide religious liberty training in some way? I don't know. they nominated themselves, and oddly, a Trump judge decided, yeah, they're probably qualified for all of this. Now, it may be, by the way, that there's no praise due whatsoever to this judge who put an administrative hold on it, not because he thought, well, yeah, maybe I better reconsider because I'll be reversed or something like that. Because, there's a pretty good chance the Fifth Circuit, who is a bunch of crazies, will uphold him. But it may be more about, well, the Fifth Circuit are a bunch of pompous a-holes as well as crazies, so they might be insulted if I don't impose an administrative stay to give them a chance to weigh in on this. Not that I think they're going to reverse me. They'll probably uphold me, but they want to have their chance in the spotlight. And if I don't issue this hold, they'll be resentful that I wasn't sufficiently deferential to them. And so I expect to be upheld, and I expect this training to go forward at their behest, but they'll get mad at me, and I don't want them on my back as having insulted them at any point in the future. Okay. So it could be just about that. So what's going on here? Right. The Alliance Defending Freedom, a far-right Christian legal advocacy group specified by Judge Starr. This is our second Judge Starr. I don't know if he's related to Ken Starr, Brantley Starr. I wonder about that. They should check into it. Well, anyway, this all ordered on the timeline initially by Judge Starr. That now suspended for 30 days. Starr himself has a bit of a history. Here's the answer. The nephew of Kenneth Starr. Brantley Starr is a Trump appointee to the federal bench and a former longtime lawyer in the Texas Attorney General's office, who is also a longtime member of the Federalist Society. By the way, don't know if you may recall this, but longtime, attorney in the Texas Attorney General's office. Texas Attorney General Ken Paxton, also himself under indictment and at the moment undergoing, I think, impeachment proceedings by the Republican legislature in Texas. But hey, whatever. This particular dispute, though, has arisen in a long-running case brought by a former flight attendant who won a jury trial on her Title VII claim, alleging that she had faced religion-based discrimination. Southwest is appealing that verdict, which followed a long and winding path taken by Charlene Carter in the case and involves, among other things, her sending photographs of aborted fetuses to her union president, because religion. As part of the post-trial orders, however, Southwest was supposed to send out a notice that it, quote, may not discriminate against flight attendants on the basis of their religious practices and beliefs. It instead sent out a notice that it does not discriminate and a follow-up memorandum about civility, which led Carter to seek sanctions against the airline. In a court contempt order issued on August 7th, which Chris Geidner and his Substack, which he calls Law Dork, right? Which Law Dork covered previously, U.S. District Judge Brantley Starr ruled that because of those steps, the airline had not properly implemented the post-trial orders and held Southwest in contempt. In addition to ordering the airline to issue a corrective notice to the flight attendants, something that the airline's counsel had already said the airline was willing to do, Starr also ordered 3 of the airline's lawyers involved in preparing the email to attend religious liberty training, and specifically by Alliance Defending Freedom, an extremist legal advocacy organization that advances far-right Christian beliefs in its legal advocacy and was not otherwise previously involved in the case. The training was to be completed by August 28th. It's just interesting that of all the people to conduct this training, he chose his uncle's favorite litigation group for some strange reason. Southwest Airlines informed Starr 2 days later on August 9th that it was appealing the contempt order to the Fifth Circuit. On Wednesday, lawyers for Southwest asked Starr to put his sanctions on hold while the airline takes its appeal. In their motion, the lawyers asked first for a temporary administrative stay on the order, which Carter did not oppose, and then more broadly for a stay pending appeal, which it notes that she does. Oh, she does? Did I say? But we'll do. Let's go back here for a second. Yeah. But he probably means he. Didn't mean to misgender the person, but Brantley Starr is Kenneth Starr's nephew, not niece. But okay. Anyway, as for the reasons for the stay pending appeal, the lawyers are blunt, arguing that the sanctions order exceeds the court's civil contempt power, violates the First Amendment, and rests on a jury verdict that the Fifth Circuit is likely to overturn on appeal. I don't know how likely they are, but that's the argument. I'll jump out of the article at this point so that we can bring you a couple other stories. But one, it's good news that there was a stay. Two, you should keep an eye on it because the stay may not be, genuinely motivated out of an interest in fair application of the law. After all, it may not even be based on embarrassment at having been called out. It may simply be, well, if you don't give the egos of the Fifth Circuit the chance to step in and scream about this thing, then you're going to find yourself falling into disfavor with them, and they may screw you over on something in the future, or they may not, give the thumbs up to moving you to the Fifth Circuit at some point. Who knows? Anyway, just thought that was interesting, and I thought we should throw that in there. And what if gosh, there's a lot here. I might have to save this for next week. But a couple other things. Well, let me bring to your attention without reading through the story. I mentioned Chris Rufo and New College and weird things happening there, just trying to connect them all to Alliance Defending Freedom and through the various hubs and spokes here. I just want to let you know, Don Moynihan and his Substack has got an interesting piece here. New College, remember the one down in Florida? That Governor DeSantis was dismantling with Chris Rufo's assistance. New College is warning about the price of populist incompetence. Subheader says, what happens when inexperienced radicals can't run public services? You probably guessed that something like this would happen. But as it turns out, competence, the ability to perform organizational core tasks, is an underrated quality. In its presence, we take it for granted. We miss it only in its absence. As it turns out, the radicals looking to dismantle the entire educational system are, in fact, they're fairly competent at dismantling it, but only through their own incompetence at continuing it in their own image. Apparently, things falling apart at New College, and in their interest and insistence at implementing the radical agenda that they've got, they've forgotten that they don't know anything about how to schedule classes, how to make sure that there's classroom space available for the classes that they desperately want to teach in place of the old ones, and all the administrative details on how to run a college are falling apart. But then they don't care because they were really out to destroy the college in the first place anyway. Something you should give some time to perhaps over the weekend. But I want to use the few minutes remaining to jump to one or two other things, since Rudy Giuliani was prominently featured here. And I guess perhaps the most important of them, and also from CNN, Caitlin Collins and Paula Reed reporting Rudy Giuliani making a desperate appeal to Trump to pay his legal bills in the Mar-a-Lago meeting. How do you like that? As it turns out, Rudy, just like everyone else, is getting stiffed for his legal bills, or the legal expenses that he says he's incurring on behalf of, or in exchange, really, for his services to the Trump campaign. And just like everybody else who provides services to Trump, he's getting screwed, and went into it thinking, well, he wouldn't do this to me because I'm on his side. Anyway, there you go. With his attorney in tow, Rudy Giuliani traveled to Mar-a-Lago in recent months on a mission to make a personal and desperate appeal to former President Donald Trump to pay his legal bills. By going in person, a source familiar with the matter told CNN, Giuliani and his lawyer, Robert Costello, believed they could explain face-to-face why Trump needed to assist his former attorney with his ballooning legal bills. Oh, okay. It's not even the charges he wanted to impose on the Trump campaign for representing them earlier, but rather the expenses of having to defend himself as a criminal defendant for having rendered quote-unquote legal services to the Trump campaign earlier. So please pay the legal bills for my legal liability, not the bills you incurred for my services in your legal liability. Okay, just wanted to clear that up. So he's out there begging for that. But at the same time, it seems like he should maybe be able to cover the bills himself, because another story about Giuliani running in parallel, this time in Business Insider, Rudy Giuliani pocketed $300,000 From who? Let's get this stupid pop-up out of the way so we can read it. From farmers. Why farmers? Well, they were not just farmers. They were farmers who were investing in an anti-Biden documentary that he was making, but never actually made, a lawsuit claims. Remember when he went over to Ukraine with a film crew to document his uncovering of all the incriminating evidence about Hunter Biden and Burisma that was going to bring Biden down? Well, one, he never got the information, and two, the film crew that was with him never produced the film that they were claiming they were going to put together, probably because they never found any footage of any of the things they said they wanted to film. But in the meantime, these two farmers, whatever they are, among other things, invested $1 million in this thing, and as it turns out, now they feel they've been defrauded. Isn't that sad? No leopards would ever eat their faces. They're on the side of the leopards. Okay, well, that's an interesting story for you to read over the weekend as well, since we're not going to be able to cram that whole thing in there. But I thought two important points about what's going on with Rudy Giuliani. All right, plenty to look forward to in the week to come. We got a nice Substack piece from Pope Hat explaining, maybe you want to read this over the weekend too, overt acts and predicate acts explained if you're having any difficulty following the theory of conspiracy law, why it works and why you can charge people who didn't actually do thus and such a thing with having participated in a conspiracy to do thus and such a thing. Well, this explains it all. Pope Hat, a practicing attorney, and able to explain those things to you in great detail. Time, though, for us to wrap it up and get the heck out of here. Lots of other things that I missed the opportunity to bring you, including, more news. Maybe we'll start the week with this, or maybe it waits until next Friday, about more activity on the internet front. Gen Z influencers quietly recruited by a company with deep GOP ties rally to impeached Ken Paxton's aide. I mentioned Ken Paxton and the fact that he was under indictment and facing impeachment. And, the judge in the Southwest Airlines case used to work for him too. And, hey, what the heck, blah, blah, blah. Spoken Hub. There are conspiracies everywhere. Just more stuff for you to read over the weekend. But if you don't want to do it as reading, you prefer to sit back and let us do the reading, Justice Putnam is about to take off on the new episode of the West Coast Cookbook and Speakeasy and bring you a collection of news stories, maybe some things that we covered here. Let's take a look. Let's see. Trump doesn't need until April 2026, as he insists, to read the evidence in his federal trial. We could read it in a couple of days. He wants to delay things until 2026. On the rest of the menu for the day, prosecutors asked a federal judge to sentence former Proud Boys chairman Enrique Tarrio and leader Joey Biggs to 33 years in prison. That sounds like good news. Let's hear more about that.
From netrootsradio.com. You have been listening to Kagro in the Morning with David Waldman.
No surprise here. 9 current or former Northern California police officers were charged in a federal corruption investigation that found violently racist and anti-gay behavior. And authorities report people are dying in the record-shattering heat wave that is baking the Pacific Northwest this week. We heard about that from Justice personally earlier this week. See you next week.